Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today we're going to talk about bar complaints, what they are, why you should or shouldn't file them, and particularly the timing of those complaints. More in just a moment. I've recently received two questions about bar complaints. One against a plaintiff's attorney and the other against an assistant district attorney. With respect to the assistant district attorney, this is what I'd say. Assistant district attorneys often have very bad jobs. They get to deal with people who are criminals, and they get to deal with their lawyers, most of whom are pretty decent folks. Most of them are public defenders, and for the most part, they wind up becoming the host or the contestants on Let's Make a Deal. They get with the defense attorneys and they work out the best deal that they can that protects the state's interest and the defendant's interests, and usually make some kind of a plea agreement that satisfies the interest of justice. Now, that's not every assistant district attorney, of course, but it's the majority. They are generally good people. Every now and then, however, one of them turns up to be not such a good guy or gal. And when that happens, there is a process where people can make a complaint. There are two ways to make that complaint. You can make the complaint to the actual sitting district attorney. You can write that district attorney a letter. And the other way you can make the complaint is to contact the state bar, because obviously every assistant district attorney is licensed by the state bar. Now, when you make that complaint, two things are going to happen. First, the assistant district attorney is going to get notified that a complaint has been made. And second, the district attorney's office is going to have to determine whether to remove that assistant district attorney from your case. The last thing in the world they want, if the case gets appealed, is to have somebody who has a personal interest in seeing you get convicted. And having to defend your state bar license, even on a spurious charge, that would be something that would make a ADA very upset and might cause them to be a little less willing to deal fairly with your opposing counsel. So you have to be careful about what happens here, because it could affect your case in ways that you don't necessarily understand. You may not like the assistant district attorney that has your case. You may think he or she is a real jerk. But the fact is, the person who replaces them could be even worse. I know a gentleman who had a trial out in the state of Oregon. And in the first trial, the assistant district attorney in that case did some things that, in my opinion, were patently unethical. But he got away with them. However, when the case was sent back for retrial, because it was reversed on appeal, and not for what the ADA did, but for other things, when it was reversed on appeal, because of the complaint that had been filed by the client, he got different prosecuting attorneys, and those prosecuting attorneys turned out to be bigger jerks than the initial one. So I tell you, it is a difficult thing when you file a complaint against a district attorney. You might be careful, because you're not always certain what you're going to get. Here's what I would recommend. If you have really been harmed, if you've really been upset by what the assistant district attorney did, wait until after your case is finally adjudicated. Wait until after your lawyer tells you that we're done, that there's not anything else that's going to happen in your case. And then, and only then, make your complaint about the ADA. Because if you do it while you are still litigating the case with the state, a lot of times the state bar, the investigators, the judges, and everybody else takes the position that you are trying to manipulate the process, and they tend to view that very unfairly. So I think it's always best if, when you file a complaint against a district attorney or an assistant district attorney, that you wait until the end of the case to do it. Now, that doesn't mean you have to. You certainly can file it anytime you like. But just be aware, doing that may increase the risks to you down the road. With respect to the plaintiff's attorney, this is what I'd say. The person who writes the question suggests that a defense attorney told her to file a bar complaint against her own lawyer. Well, that should probably raise a little bit of suspicion right there. Maybe the defense attorney feels bad for you. Maybe he thinks your lawyer made a mistake. I don't know. But it's suspect. If you think your attorney made a mistake, fire them and hire another attorney. It's as simple as that. Lawyers work for you. You are the client. You can fire them and hire them at will. You don't have to give an explanation. You can terminate them at the drop of a hat. Now, they may still get paid for the work that they did on your case. Don't be mistaken about that. But the bottom line is you can terminate them if you need to. But the best thing to do, rather than filing a bar complaint against them, is terminate them and get somebody who is credible and competent to represent you in court. I would never take the opinion of somebody who is opposing me in court as to whether or not I should file a complaint against my own lawyer. That's just not wise. Now, the other part of that question dealt with the fact that a friend told this individual that if she did file a complaint, the lawyer could harm her in some way. Well, I don't think she meant physical harm, but I think she meant that he could, harm her case. And while that's true, it's unlikely. I mean, I would think an ethical attorney would not do that, but not all lawyers are ethical, and as a result, it's not a good idea to, shake that tree if you're afraid of what's going to fall out of it. So again, if you have problems with your lawyer, if they're not doing the job, if they're not responding to discovery, if you're afraid you're going to get hit with sanctions, then you fire them. You go to the court and say, I fired my lawyer. I need a month to find new counsel. You go out and you hire a new lawyer to represent you, and you put the case back on track in that way. What you don't do is file a bar complaint against your lawyer in the middle of the case while he still represents you, because if you do that, more likely than not, he's going to withdraw from your case, or he's going to pressure you to withdraw the bar complaint in order for him to continue. So either way, it doesn't work out well for you. Bar complaints often don't go very far because many times people don't know what to complain about. But every state has the lawyer ethics rules available to them online. You can find them online. They're called the Model Rules of Professional Responsibility. And if you look up those Model Rules of Professional Responsibility, you can find what lawyers are supposed to do. And if you find that your lawyer has violated one of those rules and you don't want to fire them, you ought to at least sit down and discuss that issue with them. So that's my take on lawyer discipline and filing bar complaints. It may or may not be a good idea to do that depending on the circumstance. If you have any doubt as to whether or not you should file a bar complaint, go find another lawyer to represent you on the bar complaint. Get him to review the facts and offer his opinion as to whether you should or should not file a bar complaint. If you have any questions, please leave them in the comments down below. Otherwise, I'd really appreciate it if you haven't already to go over there and subscribe to the channel and click on that notification bell so you can be notified whenever we release a video on this channel. And at the same time, smash that like button for me and let YouTube know that this content is useful and helpful for other people. Thank you so much for watching. Have a terrific day, and I'll catch you on here next time.